My dear friends, today's subject is sociological school. Contents: what is sociological school? Who are the thinkers or jurists? Montesquieu, Herbert Spencer, DUGIT and his principle of solidarity, ROSCOE, his theory, EUGEN, EHRLICH, and Rudolf von HERBERT. Now, what is sociological school? The relationship between the individual, society, and the state are changing. In this regard, various theories propounded from time to time. In the beginning, society was governed by customs. Then come the supremacy of priests. After that, secular state emerged and dominated all the institutions. The importance of the individuals was asserted by thinkers and philosophers. There was revolutions and political changes. Welfare of the society and individual was realized. So importance of the society considered in the light of the individual. The approach made from this point of view are called sociological school or sociological approach. This school not gave attention to the ethical content, they gave importance to the actual circumstances which gave rise to the legal institutions. The sociological school is a protest against the orthodox concept of law. The school resulted out of the change in the political shift from doctrine of laissez-faire to the doctrine of welfare state of the modern century. That means previously political life was doctrine of laissez-faire and industrial development and technological revolution. All these were concentrated. Afterwards, all these shifted to the welfare state in a modern society. So, as per the school, law is the product of the will of the society. The thinkers, Montesquieu, he was a French philosopher, he was the forerunner of the sociological school. He said, law should be determined by the characteristics of the nation. They should be in relation to the climate of each country, the quality of each soil, its situation, principal occupation of the natives, religions of the people, riches, numbers, commerce, manners, and custom. All these will be taken into account. He gave importance to history and part played by economic factors. Comte is another jurist. He was a French philosopher. The object of the scientific study is society itself and not any particular institution of government. Society can progress when it is guided by scientific principles. Another thinker is Herbert Spencer. According to him, law arises from four sources. One, inherited usages with quasi-religious sanctions and injunctions of deceased leaders. Third, will of the predominant man. Fourth, collective opinion of the community. Another thinker, DUGIT, he attacked the traditional concept of the state, sovereignty, and law, and he gave new approach to these matters from the angle of society. He introduced the principle of solidarity. What is principle of solidarity? Society is interdependence of people. Interdependence was always there. Modern times, it increased because of increase in the knowledge of the man and his mastery over the world. We cannot live without the services provided to us by our fellow men. Our food, we are depending upon others. Our clothing, our housing, our recreation, our entertainment, always we are depending upon the activities of the other men. Specialization has increased. We exist only by virtue of our membership of community. Human activity should be directed to the harmonious working of man with man. This theory is called social solidarity. He said state is a human organization its duty is to ensure social solidarity. He is in favor of putting strong checks on the abuse of the state power. He said the state is sovereign, but such sovereignty has its limits. Limitation is that it has to protect the rights of all. Law is a spontaneous product of individual consciousness inspired by social necessity and sentiment of justice. Private and public law must serve the same end of solidarity. Law which does not stand the test of social solidarity is not a valid law at all. There are three formative laws: one, respect of property and freedom of contract and liability of fault. Another thinker is Roscoe. He is the chief of the School of Sociological Jurisprudence. According to the Pound, common law impresses of individual rights. In order to achieve the purpose of the legal order, there has to be a recognition of certain interests: individual, social, and public interests. Theory of social engineering, it is propagated by Roscoe. The aim of the social engineering is to build efficient structure of society. It requires the satisfaction of the maximum wants with the minimum friction and waste. It involves balancing of competing interests. What is the meaning of interest? Interest means, he defined interest means claims. Interest means wants, desires which man asserts. The aim of engineering is to build an effective structure of society, satisfaction of human wants. So, Pound classified the interest as follows: one, individual interest or private interest, public interest or and social interest. Now, we will concentrate on individual interest or private interest. This private interest or individual interest is classified into individual interest of personality, individual interest of domestic relation, individual interest of substance. Now, individual interest, private interest to be protected by law or the individual interest of the society. They include physical integrity of person, person's reputation, freedom of violation, freedom of conscience, belief, privacy, honor, reputation. They are safeguarded by the criminal law, law of torts, law of contracts, limitation of the powers of the government to interfere in the matter and opinion. Now, individual interest in domestic relations, it includes marriage, relationship of husband and wife and parents and children, and claims of maintenance. These are all comes under individual interest in domestic relations. Now, individual interest of substance includes property rights, inheritance, testamentary, succession, occupational freedom, freedom of association, freedom of industry, contract, and employment. Now we will go to public interest. Public interest. What is the public interest? Public interest means the claims, demands, or desires asserted by individual from the point of view of the political life. There are two kinds of public interest: interest to the state as juristic person and interest to the state as a guardian of social interest. It are freedom of action, honor of the state's personality, claim of society, interest of state as guardian of social interest. Now we will go for social interest. Social interest means their interest or claims or demands or desires thought in terms of social life. The social interests are classified into 6 groups. One, social interest in the general security. Social interest in the general security means these branches of law which relate to general safety, general health, peace and order, and security of acquisition, security of transactions. All these items covered under him. Second one, security of social institution. What is this security of social institution? It is domestic institutions, religious institutions, political institutions, and economic institutions are covered under this head. Third one, general morals. General morals means it covers a variety of laws relating to the prostitution or drunkenness or gambling. All these covered under this chapter. Social interest in social interest in the conservation of social resources. So protection and training of dependents and conservation of human resources. So social interest in the general progress. Next one. The social interest in general progress is classified into economic progress, political progress, cultural progress. What is economic progress? Freedom of use of sale of property, free trade, free industry, grant of patents, copyrights. Political progress, free speech and free association. Cultural progress means science and technology, free arts, promotion of education and learning. Last one is a social interest. Social interest means it is self-assertion and opportunity and conditions of a life. In sociology school, there are other two philosophers. One, EUGEN EHRLICH, and he is concerned with the social basis of law. He said the real source of the law is not statutes, but the activities of the society. The center of gravity of legal development lies not in legislation, nor in social justice, nor in judicial decisions, but in society itself. There is a gap between the norms of formal law and those of actual behavior. So he said individual is never actually an isolated individual. He is enrolled, laced and embedded into so many associations. Another scholar is Rudolf von EHRING. He developed a legal philosophy through study of Roman law. According to him, the purpose of the law is the protection of interest. Interest means attainment of pleasure and avoidance of pain. Human wants are divided into three categories. One, extra-legal wants. Extra-legal wants means belonging to nature. For example, product of soil. Second, mixed legal human wants. It is preservation of life, reproduction of law, and labor and trade. Third one, legal command. Command to pay taxes. All these comes under here. So he said property existed not only solely for the owners, but also for society. According to him, birth of the law is like that of men. It attended by the violent throes or pains of childbirth. Law is not only the means to control the social organism, law is one factor among many others. Thank you.